Well, the jury in the homicide trial of Kyle Rittenhouse is continuing its second day of deliberations in Kenosha.
The defense filed a motion today asking for a mistrial based on prosecutorial misconduct.
Joining us once again is criminal defense attorney Jessa Nicholson. Welcome back, Jessa.
Hi, Jessa.
Hi, folks. How are you?
Good. What's the difference between a mistrial and a mistrial with prejudice?
Sure. Absolutely. So a mistrial can happen whenever there's any error in the trial that sufficiently prejudices the jury such that they can't decide things fairly. So a lot of pretrial rulings talk about evidence that's admissible and evidence that isn't. Sometimes witnesses, despite being instructed, will say something that has been ruled inadmissible. Most of the time, those are good faith mistakes, is what we call it legally, so innocent mistakes. And that will result in a mistrial without prejudice, which means this happened, no one acted in bad faith, no one intended to cause it, but we know it affected the fairness of proceedings, so we have to have a do-over. A mistrial with prejudice is an entirely different animal. It's an extremely rare remedy, and it is based on the concept of someone acting in intentional bad faith. And so the written motion that the defense filed was alleging exactly that the prosecution acted in bad faith, and that bad faith acting warrants a mistrial with prejudice, which means they could not retry Mr. Rittenhouse if that were granted.
Okay, a lot happened today, and this is a little bit in the legal weeds, but maybe you can help walk us through this. The defense is claiming that the prosecutors withheld key evidence from them in the form of a high-definition file of the drone video of the night of the shooting. Is that grounds for a mistrial?
So this is, it's a really nuanced thing, because they had a copy of this video, but it was a compressed copy. And so the quality of the video, as I understand it, it was much lower than the one that the state had. And from reading the pleadings, it sounds like that was discovered on November 13th in the middle of trial. That the defense went to play a portion of that video, and the state basically said, no, use ours. Ours is a better quality. And the defense, I think, very rightly said, what do you mean? Shouldn't we have the same video? And as it turns out, they did not. They had a video that had much less data sort of included in it. I'm not a tech expert, so I can't speak to exactly how that works. But what is apparent is the information the state was working from was not the information the defense was working from. And that, to me, reads as fundamentally unfair.
So that would trigger a mistrial, do you think?
I think it could. This judge has displayed, in my view, somewhat of a reluctance to issue a definitive ruling. There's been a lot of that throughout this trial, where he would say, I'm taking it under advisement, but with a bias towards denying it. I'm taking it under advisement, and I'll consider it later. And this motion was actually made during the prosecution's case in chief, when their star witness testified, and then there were issues there, and it was again brought up, and the idea of the mistrial with prejudice was brought up when Kyle Rittenhouse was on the stand, and the prosecutor started to go down a line of questioning that related to an other act that had been ruled inadmissible by the judge prior to trial.
When will I'm sorry, go ahead. Go ahead.
So this is kind of a regurgitation of those prior issues.
When will the judge rule on this?
It's my understanding that they were taking oral argument just an hour ago. So it's possible it would be today. I would expect tomorrow. This judge has been pretty careful about ending things around 5 p.m. So it would surprise me if we heard back from him today.
So another day at least.
I think so.
All right, Jessa, we'll see you tomorrow, I guess.
Yeah, I'll see you again.
Thank you, Jessa.